think you all know the Minnesota Sentencing Guidelines Commission has proposed to change the sentences for drug crimes in Minnesota, at least the portion of changes that they had within their authority and jurisdiction to do. They made a number of recommendations beyond what they had the capacity to do, which included statutory changes for us to consider. In light of all of that discussion, a number of stakeholders came together to talk about whether or not there could be an agreement for how to make certain changes to our drug sentencing laws or drug crime laws in Minnesota. And in fact, a number of stakeholders have reached an agreement, and what you have before you is that agreement.
This is a comprehensive reform that to our drug sentencing structure in the state of Minnesota. Comprehensive reform that we, as the county attorneys in our state, believe is not only prudent, but it's extremely important. And it goes well beyond what the Minnesota Sentencing Guidelines Commission proposed. As Senator Latz indicated, they are limited in terms of what they can and can't do under the law. And we believe that the proposal that we've been working on with a number of partners, and quite frankly, partners that we don't often sit at the table with, but I can tell you that we've had very open and frank discussions about what's the right thing to do in connection with drug sentencing reform in our state, and we feel very good about the direction that this is heading. I will say that we are also continuing our discussions with our law enforcement partners in connection with these proposals. We are open to hear their concerns. They do have some concerns, and we're open to hear those. We're willing to sit down and continue our discussions with them as this process moves forward, because we hope we can reach a consensus and adopt changes which we believe will be very important to sentencing reform in our state. Let me just tell you a few other things that what this proposal will do. It will, from a law enforcement perspective, one of the things that the sentencing guidelines changes did was basically lower the sentences for all drug offenders, including some of the most serious and most violent offenders that are dealing drugs in our state and making profits on that and endangering our communities. We have concerns about that, and the consensus that we've reached is that we can create an appropriate aggravated first-degree controlled substance crime for the most serious, the most dangerous offenders in our state, and impose significant penalties, including mandatory minimum sentences for those offenders, and those penalties can be enhanced when guns are being used in connection with these crimes, or there's other aggravating factors associated with that. The proposed changes would also combine the first-degree sale and possession into one category. The sentencing guidelines have changed that into two categories. We don't believe that that's an appropriate response, again, to the most serious offenders. We also are proposing to eliminate many mandatory minimum sentences for the lower level offenders, third, fourth, fifth degree offenders, that these are individuals, and as county attorneys we look at this, we're very active with drug court programs in our communities. We believe in rehabilitation of nonviolent, chemically addicted drug offenders, and this proposal basically accomplishes that in terms of allowing us to put these nonviolent offenders into programs where they can focus on rehabilitation and addressing the underlying addictions that have driven them to use drugs. And by doing that, we can protect public safety in our state by keeping them away from criminal activity and getting beyond the drugs that are controlling the decisions in their lives. So, and again, that's another thing that we believe is important as we look at this, and that the Sentencing Guidelines Commission simply cannot do. They could not eliminate mandatory minimums for crimes that exist under current law. So there's, I mentioned this, you know, basically the philosophy is let's be tough on the real serious people, and let's treat the nonviolent, chemically addicted offenders in a way that we can address them through intensive focused treatment programs like drug court. By the way, I'm also the co-chair of the Drug Court Initiative Advisory Committee for the Minnesota Judicial Council, and I work on trying to strengthen our drug courts across our state in that capacity as well. In connection with this proposal, we've also agreed to make some changes in drug thresholds, except for heroin. Heroin is obviously extremely deadly, extremely dangerous, and can kill at very low quantities, so we would not be suggesting changing any thresholds in reference to that. And we would also agree, we have, in terms of this proposal, agreed to make the first-time trace amount, very small amounts of drugs, what we call the fifth-degree trace amounts, the first-time offense, a gross misdemeanor, and not a felony as it currently is under Minnesota law. You know, that's just a general overview of some of the key provisions in this proposal, but we think this is a proposal that is smart in terms of how we address these extremely serious issues in our society. And let's be perfectly clear. I can tell you this, I've been prosecuting crime now for 29 years as the county attorney in Dakota County. Illegal drug crimes are a significant problem in our state. Let's not underestimate that. It is, has been the #1 felony charge in Dakota County for 15 plus years. Last year it amounted to 32% of our entire caseload in terms of felony prosecutions in Dakota County. There's a lot of drug crimes. This is a big, significant issue, and we need this type of comprehensive reform to make an important difference as we try to address these serious crimes and again, deal with the offenders in a more appropriate way, both from a law enforcement perspective and from a rehabilitation perspective. So with that, I'll turn it over to my colleague John Choi with Senator Latz's permission to follow up a little bit more.
Madam Chair, members of the committee,
Mr.
my name
Choi.
is John Choi, the Ramsey County Attorney, and I'm very pleased to be here today to be in support of this bill, but also to have been a part of this process to get us to where we're at. And this process really started a long time ago, where there was this discussion that was happening at the Minnesota Sentencing Guidelines Commission about the need to have reform as it related to drug sentencing. As you well know, and you have heard, that there are great disparities with respect to how people are sentenced in greater Minnesota versus the metro, and there have been a whole host of conversations that have occurred, and they have been brought to the legislature, but things have not changed. And we have been a part of, as county attorneys, raising concerns about a number of those issues. But we have always believed, based upon our principles, that what we really needed to have is comprehensive drug sentencing reform, and that was one of the reasons why we were very concerned about the Sentencing Guidelines Commission action going into law on August 1st, as Dakota County Attorney Jim Baxter said, that we believe that that action standing alone really was not reform. What it really was and is that it would be a significant drug prison discount for the most serious drug offenders who are the ones that are selling and dealing these drugs. And so by doing this, by coming to the table here with this comprehensive package, I believe that we are able to address the people that we should be most concerned with, which are the drug dealers and those who are profiting off of the addictions of those in our community, and doing things at the bottom of the sentencing guidelines grid to address addiction, to focus on rehabilitation, and to provide also, and I want to make sure that the committee does not lose sight of an important part of this bill, which is the community justice reinvestment portions, which what we're saying is that by making these policy changes, what we want to do is we want to figure out ways to actually invest dollars into our communities to get better outcomes around drug addiction issues. So to invest in community supervision so that we can have drug courts, so that we can actually fund drug courts that don't exist in various counties throughout the state, and improve the ones that are working well in the state so that we can take it to the next level. But it's through that approach, that community reinvestment approach, where the legislature is hereby saying that we're going to figure out a way to take some of the savings that are derived, the prison bed space, and to reinvest that into our communities to get better outcomes. Because just by changing laws alone, whether we go up or down on the thresholds, it isn't necessarily going to make our communities better or healthier and have more public safety. I think another big part of this is to make sure that we have the right investments. Because if you talk to people throughout the state about communities where they want to have drug courts, but they can't get it going, and a big part of that is the funding, because they don't have the community or the county resources to do the supervision, to have the adequate probation, or the resources within the court system. And so I believe that this comprehensive package will help jumpstart and facilitate a really better approach from a law enforcement perspective and from a public health perspective about how we go about combating addiction in our communities and make for better families and communities. Thank you.
Okay, before we move on to the next witnesses, anybody have any questions for Mr. Backstrom or Mr. Choi? Seeing none, thank you for your testimony. Next on the agenda, we have, I'll read two of them here. Moira, I think that's right, Bagley Smith, and Brock Hunter. Ms. Bagley Smith, do you want to start?
Yes, ma'am. Thank you. My name is Moira Bagley Smith, and I am here representing the U.S. Justice Action Network. We are the nation's largest bipartisan coalition dedicated to criminal justice reform. Our 8 partner organizations might be considered a bit of strange bedfellows. They include the ACLU, Americans for Tax Reform, the Center for American Progress, the Faith and Freedom Coalition, Freedom Works, the Leadership Conference on Civil and Human Rights, the NAACP, and Right on Crime. I'd like to start by acknowledging that the most important goal in criminal justice reform is maintaining public safety and holding offenders accountable. Our coalition takes these issues very seriously. We're currently working on justice reform legislation in 12 states and on the federal level, and I must say that Minnesota has a real opportunity to be a national leader on these issues. It's fertile ground here for criminal justice reform, with nearly half of the current prison population are nonviolent offenders. Taxpayer money is being spent ineffectively when individuals can be better served in the community, who can be better served in the community are put in prisons and jails. Regarding this legislation, this compromise also supports valuable and necessary community and reinvestment. With the money saved through these proposed reforms, we can ensure public safety while saving valuable taxpayer dollars. So by focusing efforts on taxpayer money on serious and violent offenders and providing those who can be safely supervised with alternatives in the community, we can continue to protect the public safety while being better stewards of taxpayer dollars. To put it simply, we want to see the right people in the right places for the right amount of time, whether that's prison or a prison alternative. Minnesota has a real opportunity here. I hope you will embrace it and pass this important component of comprehensive criminal justice reform. Thank you.
Thank you for your testimony. Next, we have Mr. Hunter.
Thank you, Madam Chair. My name is Brock Hunter. I'm a criminal defense attorney in practice here in Minnesota for approximately the past 20 years. I'm also the past president and legislative chair of the Minnesota Association of Criminal Defense Lawyers. And during my 6 or 7 years as legislative chair, drug sentencing reform was our highest priority. This is an issue very near and dear to my heart, and I'm really happy to be sitting here today having this conversation. It's one I wasn't sure was ever going to happen. Minnesota's drug sentencing scheme is deeply flawed, and we stand alone from all other states and the federal courts in the lengthy presumptive sentences we impose for very small amounts of drugs. These disparities were exhaustively documented by the Minnesota Sentencing Guidelines Commission in its comprehensive report on drug sentencing back in 2007. In that report, they gave us a bit of a history lesson explaining just how our drug weight thresholds got so low for corresponding lengthy prison sentences. And in essence, what we learned from that report is that back in the 1980s, when our drug sentencing scheme was first created, we had criminologists and other experts come up to the legislature and testify about the way that the drug distribution network worked. And their testimony indicated that for those at the top level of the drug distribution network, those who were intended to be targeted by first-degree offenses facing these lengthy 86-month sentences, those level of dealers would typically deal in 50-gram increments and possess around 500 grams of a hard drug at any given time. And based upon that testimony, which I still think holds as well today, the legislature set those as our original first-degree thresholds, 50 grams for sale, 500 grams for possession, and then thresholds going down from there for lower-level offenses. That scheme did not last very long, though, because shortly thereafter, we enacted very low thresholds for crack cocaine, which was a big problem during that time. We set 10 and 25-gram thresholds for the sale and possession of crack cocaine, dramatically lower than the 50 and 500 for all other hard drugs. It wasn't long after that the Minnesota Supreme Court ruled that disparity in punishing crack cocaine more severely than powder cocaine was unconstitutional, and the legislature responded by lowering all hard drug thresholds down to the 10 and 25-gram levels, where they've remained for the past 25 years. And as a result, for the past 25 years, we have sent thousands of what are, in fact, low-level drug offenders off to state prison, causing all of the societal issues that we've been talking about for the past several months, and filling our prisons to overcapacity. The good news is we seem to have decided it's time for a change, and I welcome the opportunity to be part of that conversation. The bottom line is we have an opportunity to make very long overdue and much needed reforms here. And the MACDL was honored to be invited to the table with the County Attorneys Association, the State Public Defender, and the Justice Action Network to talk about ways in which we could all come together and agree on how to make these needed changes. The MACDL believes that the sentencing guidelines proposed changes are a great start to what we need to do to fix the problem we have before us, but they're just that, just a start. We saw a great need for additional changes on the lower end of the sentencing range for lower level offenders. We wanted to see the elimination of mandatory minimums to the greatest extent possible. And we also recognize the concerns from law enforcement and the prosecutors that the guidelines changes alone left some serious issues at the higher end of the range. There will be serious dealers who will be facing far less serious sentences if the guidelines changes go through without any additional modifications. And so we got together over the past few weeks and then worked hard and then actually came to what I think is a very good compromise agreement that addresses these issues. Did we get everything we wanted? No. We wanted weight thresholds back up at their original levels of 50 and 500 grams and going down from there, but recognized that we needed to compromise. And so we agreed to the lower weight increases that ultimately were made it into this bill. We wanted to see all mandatory minimums eliminated, and ultimately our comprehensive agreement eliminates most of them, but retains a couple for the first and second degrees for people who have prior first and second degree convictions. And we also ultimately agreed to an aggravated first degree offense for people possessing much larger amounts of drugs, 100 grams or 500 dosage units that carry mandatory minimum penalties, and enhanced penalties for those who use guns or meet other aggravating factors in addition to that possession of that 100 grams or 500 dosage units. Ultimately, I think as in any good compromise, we weren't 100% happy with all of the provisions in the agreement, and I know law enforcement and the prosecutors are probably not either, but we did reach a compromise that we feel very good about and we think goes a long, long way towards addressing the issues with Minnesota's broken drug sentencing laws as they are currently on the books. We would ask the Senate and ultimately the whole entire legislature to support this compromise agreement in every respect, as we do believe it is as good as we can do. It really is. And I think it will save a lot of lives and will also go a long way towards alleviating the overcrowding problem in Minnesota's prisons. Thank you.
Thank you. Thank you both for your testimony. Is there anybody, any member that has a question for either? Okay, seeing none, thank you for your testimony.
Thank you.
We'll call up Rich Stanek and Dennis Flaherty. It does work.
Well, Madam Chair, members, my name is Rich Stanek, Sheriff in Hennepin County, and I'm testifying today on behalf of my agency, the Hennepin County Sheriff's Office, and as President of the Minnesota Sheriff's Association. Just earlier this morning, Madam Chair, members, the Minnesota Sheriff's Association Board of Directors, several of the chiefs from their Board of Directors, and the county attorneys had a chance to meet over in St. Paul here and go through this bill and lay out some of the concerns from law enforcement. And we walked away very optimistic that they understood our concerns and that this is not the end-all, be-all. This is simply a committee hearing. And while it may pass today, that there's an opportunity to come back to the table and further clarify some of the issues that law enforcement is going to talk about here in a few minutes between myself and Mr. Flaherty. Having said that, Madam Chair, members, I have been before this committee many times before over the years, and I certainly know and respect each and every one of you, and when we disagree, we do so respectfully. However, it's hard for me to believe that you know what's in this bill and support all of its provisions. While there may be some good reason to change Minnesota sentencing laws, there is no good reason to tie this reform to a drug dealer relief plan. And let me be more specific, Madam Chair and members. I do not equate sale and possession as the same when folks who have testified say that, you know, they are equal in some way. And what I'm talking about the changes that would increase the threshold amounts for charging first degree by 100% or 150%, second degree by 200%, and third degree by 200% for drug sale and drug possession. The crimes charged most often used by law enforcement in Minnesota to convict drug dealers and protect the citizens in your districts. You know, Madam Chair, members, raising the drug thresholds only helps to increase the amount of drugs on the streets and in yours and my communities across the great state of Minnesota. And additionally, Madam Chair, members, this bill would give a free pass for many repeat offenders by no longer counting as a prior controlled substance conviction for those convicted of third, fourth, or fifth-degree drug crimes. We talked about some collateral consequences this morning with the county attorneys and others. Things that used to be felonies would now be gross misdemeanors. So health and human service workers, bus drivers, law enforcement officers, people who were prohibiting from owning or possessing firearms previously, no longer the case. Those are some of the collateral issues that we should talk about as a committee, as a legislature, together with public safety. And members, in Minnesota and across the nation, we face an epidemic of drug addiction. You know, not less than 2 weeks ago, President Obama announced that his administration plans to expand access to treatment and funding for community-based treatment services. And he sounded the alarm, rightfully so, and issued a call for all hands on deck to address this crisis across America. So later this month, Madam Chair and members, the Drug Enforcement Administration, the U.S. Attorney's Office here in Minnesota, the Office of National Drug Control Policy, a presidential cabinet appointee, and local law enforcement will partner here in Minnesota for a Drug Take-Back Day. And we're mounting a huge campaign to address this epidemic each and every day across our communities and neighborhoods across this great state. In fact, when I was sitting just prior to or listening to some of the other testimony here, prior to my coming up to the table, Madam Chair, members, I saw an email from Carol Falkowski. Many of you know her. She's very good and reputable at what she does, and she talked about drug trends, the latest report across Minnesota, and about the increases in heroin admissions and addiction at our treatment facilities across Minnesota, about increases in Ramsey County, about 12% last year of opiate-related deaths versus just the year before. But I want to be clear, Madam Chair and members, about why these efforts are so critical here and across Minnesota. You see, in Minnesota and in Hennepin County, each and every day, more people are killed because of drug abuse than in car accidents. And I know you've heard that before, but I want to reiterate it. Drug overdose is the leading cause of accidental death in the United States. And we're in the middle of a spike in drug deaths, very tragically increasing amongst teens and our young adults. Areas in greater Minnesota, from down in Rochester to North Minneapolis, the east side of Minneapolis, Alexandria, across the great state of Minnesota, have been hit particularly hard from drug overdose deaths. The increase in drug deaths is attributable to opioid abuse and heroin. from the sellers, but also meth and cocaine. The numbers for meth in Minnesota are skyrocketing at an alarming rate, as borne out in the drug abuse trends Carol Falkowski just released a few minutes ago. The meth we're seeing now is being brought here illegally from Mexico. Admissions to treatment for meth addiction in 2015 were higher than in 2005 during the height of Minnesota's crisis with drugs. In 2016, we're set to break the record for the amount of meth seized in Minnesota in 1 year by the 22 narcotics task forces that operate across Minnesota in your neighborhoods, your communities, and for your law enforcement agencies. In Hennepin County alone, over the past few years, we've had over 100 drug overdose deaths. And like I said, last year, a 12% increase in Ramsey County. And recently, we've seen a flood of low-cost, high-quality heroin from Mexico. Last year, Madam Chair, members, the Minnesota Violent Crime Enforcement Teams, these are the 22 narcotics teams that work across the state on behalf of local law enforcement, they recovered 82,000 doses of heroin, worth approximately $1 million or more, and we're at a pace in 2016 to seize more illegal drugs than in the past 5 years. Last year alone, members, Minnesota law enforcement made over 3,400 drug arrests. 2,000 of them involved meth, and officers recovered 101,000 grams of methamphetamine. Again, many of them from those very sellers that we're talking about in the bill today. Madam Chair, members, of the 3,400 arrests in Minnesota, we recovered 828 guns. 386 children had to be removed from homes because of the dangerous circumstances by which they were now living. But this brings me back to the bill, Madam Chair, members. Minnesota sheriffs take no position on the proposed changes in sentencing for drug crimes, and we defer to you, the policymakers, and rightfully so, to determine the appropriate punishment for these crimes. But I personally believe, Madam Chair, that these sentences are too long and our inmates in jails and prisons do not have adequate access to treatment options while incarcerated. Minnesota sheriffs also agree that corrections cost savings from reducing sentencing and the number of beds should be justice reinvested. And we're glad to see it in the bill before us this afternoon. But we believe these funds are best directed at pretrial and community treatment options because we should treat the epidemic of addiction by giving everyone access to treatment before their addiction leads to criminal charges and prison sentences. And for Minnesota sheriffs, however, it's unacceptable to raise the thresholds for drug crimes in Minnesota, particularly for those who sell this poison in our neighborhoods and our communities, like North Minneapolis, Southern Minnesota, Eastern Minnesota. Minnesota's peace officers are risking their lives to intervene in drug deals to protect our kids, our families, and our communities. But we don't want to make it harder to charge drug dealers, and this proposal does just that. Madam Chair, members, we talk about treatment options, but we can exercise compassion and reform the length of sentences. But I want to be clear, Madam Chair, members, no deal for drug dealers. We need very strong and consistent public safety enforcement and consequences for those that buy illegal drugs so that they will get treatment. We have the same goal at the end of the day with regards to that. And we need very strong and consistent public safety enforcement with consequences for those that prey on our children or vulnerable adults so they go to prison where they belong. I don't know anyone here today that could explain to the mother of a teen, like I've had to do many times, whose child died from a drug overdose, that Minnesota's drug dealers, those who sell, need more chances. Madam Chair, members, Minnesota's law enforcement and public safety professionals want to work with you. We want to address your concerns, but we also want you to hear our concerns of those that we are sworn to protect and serve every single day. Sheriffs don't make public policy, but we do advocate for good public policy, and we enforce the public policy that you put in place in the form of laws. Members, thanks very much for allowing me to testify this afternoon on behalf of the Hennepin County Sheriff's Office, the 1.2 million residents in my county, and the Minnesota Sheriff's Association, my 86 colleagues who are out there every day doing the right thing for the right reason in protecting our citizens. Thank you.
Thank you, Sheriff Stanek. And I just have to say, after you told us all the increases in the drug crimes and so forth, I think one could argue that our toughest of anybody's drug laws are not working. And so I don't know making them tougher is the answer or not. But Mr.
Well, Madam
Flaherty,
Chair, members, if I might, just in
Mr.
response to that, if Madam Chair, if members of this committee or legislature believe that not being tough on the sellers. Now, I understand when you're going to raise the threshold of possession and selling, I may see my way clear to seeing about possession. But selling, those who are out there making a profit by selling that poison in our communities to our children, our brothers, our sisters, our aunts, our uncles, and others, I don't think that Minnesota's law enforcement community is up for that. And that's why we're asking, when you take a look at this bill, take a look at those specific provisions. A 200% increase in second-degree and third-degree threshold provisions for those who sell, or 100 and 150%, I can't remember which one, for first degree. That's what we're talking about. That's our concern. That's what we want you to look at.
My name is Moira Wilberg, and if you were judging me by my criminal record alone, you might think that I am a high-level, sophisticated drug dealer. I was arrested, charged, convicted, and sentenced to prison for the most severe drug offense in Minnesota, sales in the first degree. The streets are no place for a 17-year-old runaway, and the addiction that fueled my crimes was a result of my, a misguided attempt to address the emotional pain caused by years of homelessness, sexual exploitation, domestic violence, and an HIV diagnosis, all before my 20th birthday. I was selling small amounts of drugs, an amount one person could use in 1 or 2 days, to support my own use. After selling to the same person on 3 separate occasions, I was arrested for a first-degree sales crime because the cumulative amount sold was 10 and 1/100th of a gram, which is just over the threshold, the current threshold for a first degree. Although my drug sales were not motivated by greed, I still recognize the harm caused to my community, my family, and myself by using and selling drugs. Luckily, I have had access to life-changing interventions such as cognitive skills classes, therapy, and a strong support system. Although some resources are accessible in prison, only a fraction can participate due to a limited capacity. They are far more readily available in the community without the extra cost, family separation, life disruption, and collateral consequences that result from incarceration. I am not a drug dealer. I'm a wife, a daughter, and a sister. I'm a taxpayer and I'm a registered voter. I have rebuilt my credit and today I'm a homeowner. I have completed my associate's degree and I'm a current student at Metropolitan State University focusing on individualized studies on health and social disparities. I'm already taking the steps to continue on to law school next year. Because of the severity of my offense, I was turned down for minimum wage jobs. Luckily, volunteer work opened the door to employment, and I now have a successful career in the nonprofit field. I am active in my community. I serve on a board of directors for a local nonprofit and volunteer for agencies and causes such as the Second Chance Coalition. I have been invited to several national conferences due to my activism. Since my successful completion of parole in February, I have been honored to be allowed to visit and share my story with the ladies at Shakopee and the Ramsey County Workhouse. Ladies who have stories just like mine. I didn't need a long prison sentence to become the woman I am today. I needed compassion. I needed community support. I needed to be taught how to heal from and cope with the events of my past without using drugs. I just needed help. The changes we are supporting today will allow many like me to get the help they need instead of a long prison sentence. Thank you.
Thank you very much, Ms. Wilberg, and that's an amazing story, and congratulations on your changes in your life and how well it's going, and sorry to hear about the issues you had. Ms. Evans, do you want to go now?
Thank you. Madam Chair and members of the committee, my name is Gina Evans, and I currently serve as the Community Outreach Director at Minnesota Adult and Teen Challenge. I just want to thank you for taking the time to consider this very important legislation. I would first like to say that I am in no way blaming the system for my behavior. My choices were my own. I'm just asking the question, what if addiction was treated as a public health issue? What if my children had ended up in the foster care system? What if I had received the help I needed instead of incarceration? What if? I started using meth intravenously when I was 15 years old. I was in 8th grade in middle school. I had my first baby at 19 years old. It was then that I was charged and convicted with my first felony at 21 years old. I was caught with 1/10 of 1 gram of methamphetamines. And Senator Newman, just to give you an idea of what that looks like, if you guys want these, I can have somebody bring them over, but that's what 1/10 of what 1 gram looks like, and that's a felony conviction.
I think we would like the pages to bring that around so that we can see that, because it makes it more understandable.
I was between college classes at a friend's house. Well, you can take them all, but I'm going to talk about them one at a time. Thank you. I was between college classes at a friend's house, and his house was raided. I wasn't even using drugs at the time. The meth I had in my wallet was left over from the weekend before. I did 6 months in Dakota County Jail before I was finally violated for dirty UAs for marijuana. This was my first felony. I lost my student aid for college. I served 4 months in prison for this charge. My 3-year-old daughter actually learned to read in the Shakopee Women's Prison visiting room on that charge. My second 5th-degree possession for drugs was for trace amounts. This is what that looks like. I was hanging around with drug dealers that were arrested 2 weeks prior. When they came, you can take both of them. When they came to my house, I was out of dope and sleeping. I hadn't used in over 10 days. I was charged and convicted of 5th-degree trace amounts. We lost our housing, my daughter and I. With 2 felonies, finding housing and finding employment for a 23-year-old with no education and no experience was difficult, to say the least. My 3rd felony conviction was also for trace amounts. I sent that one as well. And my 4th and final drug conviction was for 3/10 of a gram of meth. I served 14 months in Shakopee Women's Prison for the drugs that are in this bag. My first trip to Shakopee, I served 14 months in Shakopee Women's Prison, and eventually the state of Minnesota permanently terminated my parental rights for my 2 children. I was lucky that my mother was in a position to care for my 2 children. This is not the case for everyone in my circumstance. These are my drug convictions. They're not my only convictions. I have some others and a very interesting story to share in regard to my other felony convictions. My first trip to Shakopee for basically 1 line of meth was in 1996 for possession of 1/10 of a gram. I would have considered myself a very low-risk offender at that time in my life. I was very young and very impressionable. I met a group of women while I was there that were all part of a check forgery ring. We exchanged numbers, and they became my new drug connection. When I didn't have money for meth, they showed me a new way to make money. My second trip to Shakopee was in 2001 for check forgery. After this incarceration, I left Shakopee with a written recipe for lithium-based methamphetamines. I will not implicate myself by sharing what I did with that information, but I am truly lucky that I'm not dead. Our system is broken. We are treating our citizens that struggle with a disease that is cunning, baffling, and powerful as criminals. Would you throw someone with diabetes in jail for eating a Twinkie? And I say that to keep it light, but think about the implications of that. Madam Chair, I had very little control over my disease, over this disease called addiction, and my poor children had 0 control. The person that I am sitting in front of you today, as many in this room, law enforcement, county attorneys, and others can attest, I am a woman of integrity. I'm a very passionate advocate, an excellent employee, a mother, and a grandmother. But what if addiction was treated as a public health issue? And what if my children had ended up in foster care? And what if I had received the help I needed instead of incarceration? Our system is, for all of those trapped in the cycle of criminal behavior caused by addiction, please do the right thing and pass this legislation.
We are supportive of Senate File 3481, and we urge its passage. We've heard testimony about the work that's gone into this, the compromise. And like any compromise, concessions were made, and I think like most of the folks who have been following this law, I would agree that it's not perfect. However, it is very good. and it's primarily very good because it addresses a significant defect in our current system, which leads to people whose drug conduct, which is relatively low level, and I say that it's relatively low level because it is born out of their desire to use and their addiction, and not, to the contrary from some of the testimony from law enforcement this afternoon, born out of greed or a desire to profit off of putting poison in our communities. And I think, the testimony that we just heard from my friend Moira really brought that to that point home. The threshold weight levels in our current law are simply too low to serve as an adequate proxy for sophisticated levels of involvement in the drug trade. Because this bill remedies that, it is going to create opportunities for people who are suffering from addiction to get the treatment that they need in the community while on probation, instead of being sent to prison. And that will lead to better long-term outcomes. It will help people lead better lives once they have moved through the criminal justice system, and it will have significant impacts for our state's current prison overcrowding situation. So for all of those reasons, I urge you to pass this bill. Thank you.
Thank you. Next is Kathryn Mollen.
Madam Chair, members of the committee, good afternoon. My name is Kathryn Mollen. I'm the Policy and Outreach Coordinator for the Minnesota Catholic Conference, the policy voice of the Church in Minnesota, the Catholic Church in Minnesota. We offer our testimony today in support of SF 3481, which would modify drug sentencing laws. We think that the changes better address than current laws both the dynamics of drug trafficking today, as well as the reality of substance abuse and associated criminality, which can derail the lives of so many on the margins of society, some of the examples of which we just heard. In March, we testified at an informational hearing of this committee in support of the Minnesota Sentencing Guidelines Commission changes to the drug sentencing guidelines by seeking to separate those who are chemically dependent and in need of help from those who are bigger players in the narcotics trade. The MSGC modifications were an important first step in both relieving a crowded prison system and addressing the challenges of a prison population affected by substance abuse, mental illness, family fragmentation, neglect, lack of education, and perhaps most distressing, a lack of hope. We believe that Senator Latz's legislation, the product of a tremendous amount of work among prosecutors, advocacy groups, and criminal defense attorneys, who we just heard many of those testifiers today, maintains the spirit of the MSGC's recommendations and fosters the twin goals of promoting public safety and maintaining a criminal justice system that seeks not merely to punish, but also to heal and restore. Dangerous criminals and those who inject disorder and cause harm to the society, such as drug traffickers, should be punished appropriately, including with lengthy terms of incarceration. As a society, however, we must, over the long term, move towards our resources away from building more prisons and instead move towards better and more effective programs aimed at crime prevention, education, rehabilitation, substance abuse treatments, and community supervision and reintegration programs. To that end, this legislation responsibly notes the importance of directing savings generated by the reforms in reinvestment programs that address the problems of substance abuse addiction in our communities. Pope Francis has said that the name of God is mercy. The experience of God's mercy and experience which is shared across faith communities compels us to consider ways in which mercy can be the perfection of justice and prevent it from becoming the application of inflexible commands. The realm of public policy is not exempt from these discussions, and we are encouraged by the way in which different groups were able to come together civilly and explore together how we can truly make a difference in our criminal justice system by making it more just, precisely by distinguishing between those who are grave threats to our community and those who are in need of mercy and care by our community. In this way, this legislation can be a model of civil discourse and the pursuit of common good. We commend all parties involved and are grateful for their service. Therefore, in light of the legislation's potential for fostering public safety and rehabilitation of those suffering from substance abuse, as well as the way in which it transcends ideological and partisan boundaries in service of the common good, we wholeheartedly urge its passage. Thank you very much for your consideration.
The So what we've got are statutory changes that go well beyond what the Guidelines Commission could have done, but moves in the direction of their total package of recommendations, because they did have recommendations actually for 2 aggravated first-degree drug crimes, but that required statutory changes, so they could not adopt them themselves. I would reemphasize what the chair has already mentioned. We do have an epidemic of drugs in Minnesota. We have a scourge in our communities around the state. And particularly with meth, now coming high grade from Mexico, particularly with the opioid and heroin addictions and overdoses. And I think what that demonstrates is that our current regime, our current statutes, are not working to stop the drug crimes in Minnesota. My own belief is that as long as there is a demand, there will be a supply. And we should focus more resources on curbing that demand, treating the addictions, or intervening even earlier before the addictions become an issue. But I also fully agree that for those who are entrepreneurs who are really making a living off of feeding those addictions, they need to be put away. And this bill creates that balance